And so to the single count Class B felony, possession of methamphetamine on school grounds, to that count, how do you plead? Guilty or not guilty?
Guilty, Your Honor.
Brief factual basis for the state?
In this case, Your Honor, back on September 15th, 2025, Officer Chase Johnson of the Valley City Police Department was over at the high school here in Valley City, North Dakota, at a volleyball game. He was notified by an individual that there was a suspicious item located at the top of the stairs that was leading down to the gym within the school. Officer Chase retrieved the item. They later obtained security footage and identified the defendant. Within that footage, she had a small bag that, based on their training and experience, and later determined to be methamphetamine by the lab. It had fallen out of her pocket. The defendant was viewed within that video camera holding her children's hands and walking up the stairs out of the game and through the high school, at which time the bag had fallen out of her pocket of her sweatshirt. The defendant was interviewed about this and in essence agreed that was her, but didn't really understand how the item had gotten into her pocket, was what I understood from the interview. The lab did later test the substance, and it tested to, was determined to be methamphetamine, and it weighed in at 3.426 grams.
All right. Ms. Downs, is that what happened?
No. I do not believe I was wearing a hoodie that day. And after the footage and on top of me not knowing, there was no, you couldn't tell where this bag had come from that fell. It was not on my persons. I did have a diaper bag. And I could have brought the diaper bag here. Inside the gym, before me and my boys left the gym, I keep crayons, coloring books in the diaper bag. So from prior experience, I zip up the bag because I have dropped things out of the bag before. Because this substance was not on my persons, the only place that it could have been, I think, would have been on the side of the diaper bag that the cups go into. There is a slit in that expands, that allows whatever cup you put in there to expand to the size. That slit goes all the way down to where the bottom of the cup sits. And therefore, something could fall out of that. So it came from the diaper bag.
So Ms. Downs, you understand that you're pleading guilty to possessing methamphetamine on school grounds?
Yes, I am. I was just not knowingly aware that it was there.
Well, that's an element that you willfully possessed the item on school grounds. And so by pleading guilty, is that what you're saying? Is I willfully possessed methamphetamine on the real property consisting of a school? Because if you say I didn't do that, then I don't accept your plea.
No, I did, Your Honor.
I think the disagreement with the factual basis, Your Honor, is it can be seen in the video coming from the diaper bag, not from the sweatshirt, was the issue that we had with the factual basis. Not that it's a huge discrepancy, but it's a discrepancy, and so I wanted her to point that out.
Okay. And so to the extent that that would be a defense, and I'm not saying that it is or it isn't, but to the extent that it's a defense, do you understand that by pleading guilty, you're waiving any and all defenses that you could have had?
I am, Your Honor.
And are you asking that I accept your guilty plea and find a sufficient factual basis?
I am, Your Honor.
All right. So you're not disputing the fact that you were at school. You're not disputing that this occurred in Barnes County. You're not disputing that the substance that was found was eventually tested and determined to be methamphetamine. You're not disputing that it came from you. Is that right?
Yes, yes, Your Honor.
Just not out of your sweatshirt, instead out of the diaper bag.
Yes, Your Honor.
All right. Any reason why I shouldn't find an adequate factual basis, Ms. Chisholm?
No, Your Honor.
All right. Court's going to accept Ms. Downs' guilty plea, find the same freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support the plea. What's the state sentencing recommendation?
In this case, Your Honor, the state, I don't typically talk about our staffing stuff, but Ms. Downs has been in drug court before. For the court's information, she did not successfully complete it. I'm blanking on which year she was in drug court. It was probably like 3 or 4 years ago. It's a few years back that she was in drug court. I'm unsure if drug court is appropriate for her. As I mentioned, the drug court judge, Shockman, conditionally accepted her on the indication that this court believes it's an appropriate disposition. If the court believes drug court is appropriate here, the state would recommend 3 years with the Department of Corrections. I don't believe she has any credit. It looks like she had an unsecured, her warrant was served on the same day her bail order was issued, and her bail order was issued in an unsecured amount. So I think she was arrested and seen immediately or shortly thereafter. If the court chooses to give her 1 day of credit, that's fine with me as well. And then if there is a drug court disposition, then the state would recommend suspending all of that remaining 3 years. If there's not a drug court disposition, I think incarceration is appropriate at the discretion of the court. 3 years of supervised probation with the conditions found in Appendix A. I would ask the court to waive the administrative fee in this case and issue an order, $100 facility fee and a $25 victim witness fee to be payable as collected by probation. And then if she is not sentenced to drug court, then I would ask the court to order some incarceration. I'm not sure what is an appropriate time, but without drug court, the state's recommendation was originally 3 years with none of that suspended.
So, Ms. Duffy, I haven't had this come up in Barnes County. I recall when I served as a defense representative on a drug court in Cass County, when we conditionally approved someone, the notice made clear that it was a conditional approval. And this approval that I have doesn't mention that. So in the future, it's not that I disbelieve you in any respect, but in the future, at this point, or from this point moving forward, if there's going to be a conditional approval or a conditional denial, can you indicate on the form that it was conditional, whether it's with an asterisk and then an explanation on the bottom, just so I don't look at that and move forward thinking everyone's on board with it if they are in fact not.
Sure. Yep. That I've not had this come up either. Our drug court's now been in effect long enough that some of our original people who have been in drug court are reapplying for drug court. So this is kind of new territory for us too.
Sure.
Related to the state's recommendation, if the court does not put her in drug court, as I mentioned, I did look that up now. It looks like she had a 2019 case, so it would have been the very beginning of our drug court when she first came in. She did pretty good in that case or in that drug court for a while, and then there was just dishonesty issues that in essence caused her to be terminated. She was revoked on that one and resentenced to I think 3 or 4 months with the drug patch. I don't think had additional incarceration time. Her criminal history mostly just includes some driving stuff for quite a few years until that 2019 case. She had an endangerment of a child, ingestion, possession of meth, and drug paraphernalia. That case, the factual basis of that case, in essence, involved her overdosing, and her child at the time was younger. She probably was in like the 9 or 10-year-old age range, maybe a tish older than that. But her child observed her overdosing and ran out in the street and screamed for help, and somebody came and in essence saved her life. So that was the underlying criminal history that brought her into drug court on the first one. I firmly believe she's a person with an addiction, whether factually the methamphetamine was in her sweatshirt pocket or the diaper bag. Frankly, it's worse if it's in the diaper bag. It's even more concerning to the state if it's in the diaper bag versus her sweatshirt pocket. But nonetheless, she's here and taking responsibility, and the state certainly appreciates that. But the addiction, the state's biggest concern, and the reason the state continues to waver on the fence of whether drug court's appropriate, is that there's kids here. She's previously overdosed in front of her child, that I have no doubt has had incredibly lasting effects on that child. And again, we are in a situation where there's more children that are younger, and there's a substantial amount of methamphetamine that's, according to her, in their diaper bag instead of her sweatshirt pocket. And that's where the state's, in essence, wavering on the fence of whether drug court's appropriate. That's where that comes from.
Understood. Ms. Chisholm, your thoughts on disposition?
I just want to clarify that we've never encountered a conditional drug court approval, and I think our understanding was is obviously, of course, this court has the ability to approve or disapprove of a plea agreement. I don't think we necessarily fully understood that conditional meant conditional, as Ms. Duffy explained it, because my client was told by drug court that she was accepted into drug court, and that was also my understanding. But either way, we're arguing that drug court is appropriate, Your Honor, for the reasons that Ms. Duffy just argued. In 2019, my client was a much different person. She was in a dark place with substance use issues. Her mental health was not well. She's in a very different place now, where she has the ability and would like the opportunity to take advantage of what the drug court program offers. I believe the drug court program is intended to help people like her, people who have substance use issues that rear their ugly heads in times of stress, as this court's aware. She is in the midst of a contentious divorce process, and so that's been the underlying cause of this rearing its ugly head again. But as far as mental health, Your Honor, she's in a much different place. Her children are her life, quite frankly, and a priority here. She's been attending to her mental health by going to therapy. She's been on the drug patch. She's got medication management put in place. She's been seeing her therapist, her medicating physician. She would like to take advantage of the drug court opportunity if the court saw fit. And I'll ask the court to speak to Ms. Downs also. She can explain a little bit further as to the difference between 2019 and the present, Your Honor.
Thank you. Before I do that, I'll just make a general comment on the conditional approval. In Fargo, when I came across this, it was usually the treatment provider that had some objection, and it was most of the time conditional on some sort of inpatient treatment before drug court. So sometimes we would get conditional approval for a defendant on the basis that they first do a stint in inpatient treatment, or they first do some condition, and then the drug court team would consider it approved. I always a judge always has the ability to say, I'm not going to impose drug court, even if drug court has been approved by the drug court team. That decision rests with the sentencing judge. But when I think of conditional approval, it's usually the type where the team is saying, we will take this person if before they come to us, they do X, Y, and Z. So maybe I'll talk with Judge Schachman about that, or bring it up at a judge's meeting, because it's unusual. But nevertheless, I want everyone to be clear that right now, whether it's conditional or not, whether it says conditional or not, I think the sentencing judge always has the ability to say, here's my sentence, and it might be inconsistent with what the parties had recommended, unless there's a plea agreement and I'm bound under Rule 11. That's a different story. But if it's presented to me after the plea agreement deadline or as a non-binding plea, I always have the discretion to impose a different sentence.
Just for clarification for the state, the use of the word conditional here is not synonymous to your experience. She didn't have a checklist of things to do. It was just whether the court feels it's appropriate is all.
Sure. And like I said, I think that's a terminology thing that I'll take up with Judge Schockman. And I think Lefevre is sort of, I think he took over half of that treatment court, didn't he?
Not half, but one.
A portion of it.
Yeah, some,
Yeah.
yes, yeah.
So I'll talk with those two judges about that language just to make it easier for all of us. And I'll bring it up at a judges meeting, but we just had a judges meeting, so it's probably not going to happen for another 2 or 3 months. So thank you for that information. Ms. Downs, is there anything that you want to tell me before I make a decision?
2019, going back to 2019, I had never been in treatment. I didn't try to get treatment before. Even though I had spent 3/4 of my life prior to that in active addiction. I got emotional because that day when I overdosed and my daughter found me, it changed the direction of my life. I didn't realize how selfish I was and what she was losing prior to that. She had a good life, but she didn't have a present mom. And going to treatment that first time in drug court, it was the chance I needed. And I had people in treatment when I did inpatient treatment, when I had started drug court the last time. And I had a counselor there that absolutely changed my life. As far as being not or lying to be kicked out of drug court, I had called my probation officer and told him that I had screwed up. I had relapsed a few times. I didn't get kicked out of drug court on a relapse. It was an unsubstantiated rumor, I guess. When I had went back to court, and I forgive me, I can't remember the judge's name. I had never lost custody of my daughter. Child Services was never involved in my case. And so he thought probation would be sufficient enough. I've been in Valley City, I believe 9 or 10 years. I've lived at 2 different residences, my prior residence and the one I live in now. Since being kicked out of drug court the last time, I started a business. My business is registered with the Secretary of State. I have clients all around Valley City in different areas of the community that haven't given up on me after all these things have come to light. I've worked hard over the years to create my professional, how people see me, because it's important, and I wouldn't take that day relapsing in front of, overdosing in front of my daughter back. Because a part of me believes that that day, after that, my daughter's relationship with me changed, and it only brought us closer. I was always upfront and honest with her. Now I don't even, if somebody came and told me they caught my daughter hitting a vape, she saw firsthand what drugs can do. And I think she decided to go the complete opposite route, and she understands how bad things can be. And I think I've raised a great kid on my own for years. My daughter is an amazing person, and everything I do is for my children. Again, I'm a single mother, living in the same house, paying all my bills, which my business allows me to do. My clients that I've acquired over the years, I have clients that I've been cleaning for 5 years, going on 6. I don't have a criminal record other than a couple driving offenses prior to drug court. I have a drug problem, and it has taken me not before my divorce. I had almost 3 years clean before my relapse, and early on in treatment, they weren't far and few between. I had to learn. I had to live life, and I had to learn. And every time I came to a different situation, I had to learn how to go through that and reach out to the right people. And the problem with my divorce is that I reached out to the wrong person for help when I should have reached out to my recovery community, which hadn't been, it had been a while. Twins, my husband, he farms, so I was a single mom during planting and harvest. I didn't get a chance to go to as many meetings and things. And so my recovery community kind of dwindled there for a little bit. And when I reached out for help, matter of fact, earlier in 2025, I called my husband, and after I kicked him out of the house, asked him for help. I wanted him to take my boys for 30 days so I can go to an inpatient treatment, and he told me no. He couldn't do it, and I fell harder after that. And
I'm going to interrupt you for just a moment, and it's because I also preside over your divorce case.
Yes,
And
yes,
there are matters that are still pending,
yes,
and because your husband's attorney isn't present,
yep,
I can't hear stuff that might
Okay.
affect that case.
okay,
So I understand this is your right for elocution, and I'm giving you an opportunity to tell me anything you want. But if you can refrain from talking about things that might impact that divorce case,
sure,
I would appreciate it, just because Mr. McLean and your husband, they're not present. And I don't want ex parte communication, because in this case, the state is here and your attorney is here.
Yep.
But in that case, Mr. McLean is not present. And so I don't want this to be considered ex parte communication.
okay,
Ex parte just means one-sided. Okay.
Okay.
So you can tell me what you want, but if you can avoid talking about issues with Mr. Downs, I would appreciate it. Okay.
okay.
You can
Yeah,
continue.
I wasn't frequently visiting my meetings like I had for a long time to stay clean in those almost 3 years. I reached out to the wrong people. I didn't reach out to my recovery community like I should have. I do not feel like I am a threat to the community, my children. If that were the case, I feel like child services would have been involved. I don't even know their names, the counselors over there. I'm winging motherhood. I didn't have a very great example of what parents should do. I'm learning as I go, and like my attorney established, I'm a different person than I was then. And I want the chance to make things right, so much so that I just turned in my application and transcripts to go back to school just a couple weeks ago. So I'm trying to change my life, but I'm also winging it, and I'm learning from my mistakes and how to move forward with things.
And Ms. Downs, if I give you another chance in drug court, and it's not called drug court anymore, it's called treatment court. So I give you another chance in treatment court. Do you understand that probably will be considered your last chance? And if you have a problem and things go sideways in treatment court, Ms. Duffy is undoubtedly going to ask for prison time, which will negatively affect not only you, but your family in a very significant, very painful way.
I do.
Is there anything else that you want to tell me?
Celebrated 10 months clean just last week. It's not because of the accountability from the drug patch, because if you look at the results from the drug patches, I know they have been coming back positive for methamphetamine, small amounts of. If you go back to my first patch and even this last one, they are relatively within similar levels. And my first one was put on not too long after I was arrested for this. So when I was arrested for this, I had already been clean 4 weeks. As a matter of fact, within 3 days, wiggle room, my clean date is July 10th.
I forgot she had a drug patch violation, Your Honor. She does have an additional 2 days. It looks like she's forgot. Two total, right? Or is it 3?
I think it was 3.
3, okay.
Yeah.
Okay. There's 2 back.
So it's 2 once and then 1 day.
Yeah.
Okay.
Anything else, Ms. Downs?
With the frustration of those patches popping positive, I went and got a hair sample drug test down in Fargo. I also take UAs at treatment that I've been going to for months now. And they have all, I've tested negative for my hair sample drug test and the UAs I've been taking at treatment. Other than that, I have nothing else to say.
Just for your information and edification, part of the difference between a patch and a UA and a hair sample is what we call a cut score. And what that means is when a lab takes a sample, before they say positive or negative, there's a certain minimum threshold that they have to quantify. And the patch threshold, that cut score, is 10 nanograms per milliliter for methamphetamine. For urine tests, it's usually 250. For hair samples, it's usually 500. So it's not unusual for a person that tests lower than 500 or lower than 250, but north of 10 to test positive on a patch, but test quote unquote negative on a urine sample or on a hair follicle sample. So sometimes the amount of substance in one's body remains the same, but depending on the method that a person uses to test, that person might be considered positive or they might be considered negative. That's an important fact for you to put in the back of your head, because treatment court uses different tools to ensure compliance with sobriety. And those tools have different cut scores that might affect whether you're positive or not. Understood?
I do, yes, Your Honor.
Okay. Anything else you want to tell me before I make a decision?
No, Your Honor.
And I do note that there were 2 affidavits for 24/7 violations. On the first one, the court found Ms. Downs was not in willful contempt for violating the court's order. But on the second one, the court did find Ms. Downs in contempt for violating the court's order and imposed a 48-hour hold as a result. With that, Ms. Duffy, is there any 24/7 credit I need to calculate?
He's been on 24/7 since the beginning. Looks like the court's first bail order was issued September 25th of last year. I can run a date calculator on that. I don't know what it is.
If you would, please.
To today, that is 237 days.
And that's what you're asking for credit on the 24/7 program?
Yes, Your Honor.
And with your recommendation, you didn't mention 24/7? Is it your intention that she stay on that program for a period of time, or is that something that you're asking treatment court take care of?
She's sentenced to treatment court, that they would have the discretion in order to do that. If she's not, that's up to the court. Typically, I don't do that. I leave that to probation.
Understood. Ms. Chisholm, do you agree 3 days jail credit, 237 days 24/7 credit?
Yes, Your Honor.
Ms. Downs, no matter what sentence I impose, 3 days jail credit, 237 24/7 credit? Shake it. You're
Yes,
shaking your
Your Honor.
head, but I need words. Okay. All right. Ms. Downs, I understand addiction more than most. Like you, I've been around addicts almost all of my life. All of my adult life that I've worked as a lawyer, I've been involved and represented hundreds, if not thousands, of people that have drug issues or alcohol issues. I grew up in a home involving alcoholics. There was lots of violence in my home. My brother's a drug addict. I've been around addiction all of the time I can remember. I understand that treatment is a non-linear, progressive thing. It doesn't go from point A to point B in a straight line. Oftentimes, it takes people several treatment opportunities before treatment starts to work. I'm a firm believer in treatment. And I think that it reduces not only costs to the criminal justice system, but I think it benefits society in real tangible ways. Not just a defendant in particular, but a defendant's family, their employer, their landlords, their friends and family, the community in general. Having sober, productive members of society benefits everyone. I also am keenly aware of how a non-sober person interacts with the world. And I'm keenly aware of how it impacts children in particular. Children are resilient people. They put up with a lot of stuff they just assume is normal, when in fact, it's not normal. And the fact that you've raised a good child who has seen unquestionably horrific things, that's not normal for your children to deal with. And it's not something that the court is going to allow to continue because it's not normal and it impacts those children in real ways, not just now, but potentially forever. What would have happened if you couldn't have been revived and your daughter witnessed you overdose and die? Think about how that would affect her forever. The fact that the drugs in this case, you're saying came out of the diaper bag. I agree with Miss Duffy. That's way worse than drugs coming out of your sweatshirt. The fact that it was in school, the reason the legislature makes this a more severe crime is because they're trying to keep drugs out of school. Those kinds of facts aren't helping your cause. And even here, I gave you the benefit of the doubt once on a drug patch issue and not on the second drug patch. You're struggling. I think you need help. And I want you to understand that the responses the court has to situations like yours, I have a couple of options. I can try treatment again with the understanding that that's the carrot. And there's a big stick that involves the DOCR after the fact if you don't comply with treatment. I could go the other way and incapacitate you, meaning incarcerate you so you're unable to use substances and force your sobriety. I could do that too. There aren't retribution type options. This isn't a crime that has a victim in a traditional sense. I'm not saying it's a victimless crime because, for example, a child very easily could have picked up that substance and not turned it over to law enforcement and not known what it was and used it and overdosed, died. Just in the news yesterday, there was a kid that brought THC gummies to the school in Fargo. Several students got sick because their parents didn't lock up their THC gummies. And this is a real issue and it affects more than just you. It affects your children, it affects the community. So it's not victimless, but it's not like a assault where I can say that person's all bloody and beaten up. It's not a victim in that sense, but it's not victimless. The legislature has not imposed minimum mandatory penalties. They've talked about imposing minimum mandatory penalties for this offense several times that I'm aware of. It's been a discussion. I want you to understand that if I give you another chance, it is the last chance, Ms. Downs. I would encourage you to rely on your treatment community and treatment providers, regardless of the sentence you get, to help you through difficult times. But once you're an addict, you're always an addict. Doesn't matter if you're in remission, doesn't matter if you're actively using, you're just always an addict. That doesn't ever change. You can be an addict in remission, you can be a sober addict. But once that designation has happened, it's a demon you're going to struggle with every day forever. And I certainly hope you can conquer that, because if you don't, my options become very limited. I'm going to adopt the state sentencing recommendation. I'm going to approve treatment court at this time with the stern warning. This is the last time that I'm going to do that. And if you come in front of me on a revocation, you likely will be leaving that courtroom in the custody of the sheriff. And that's not what I want to do, but it forces a lot of domino effects, in particular with your children. Because if you're in prison, where are your kids? That's the bottom line reality. And you understand, or at least you better understand, that you hold the keys to the kingdom, the keys to the jail cell. So this is the last time that you're going to get this break. Sentences as follows: 3 years Department of Corrections and Rehabilitation. First to serve 3 days in the custody of the Stutsman County Correctional Center. Credit 3 days actual jail time served. 0 days good time credit. Balance suspended for a period of 3 years. Standard conditions of Appendix A. I'm waiving the criminal administrative fee. I'm waiving the facility improvement fee. I'm waiving the victim witness fee. Successful participation and completion of the Stutzman Barnes Treatment Court, Adult Treatment Court, is required. (24/7) credit, 237 days time spent on the 24/7 sobriety program. Treatment court to start as soon as possible. Is the next meeting Thursday, Ms. Duffy?
You should start Thursday. Yep.
So treatment court will start Thursday, May 21st, 2026. You'll need to report to probation within 1 working day. Tell them that I just put you in treatment court, and they will get that lined up. DNA sample required, fingerprints required. Anything I missed, Ms. Duffy?
I don't think so. Thank you.
Ms. Chisholm?
Oh, Your Honor, thank you.
Ms. Downs, sincerely, good luck. I hope you get what you need.
Thank you, Your Honor.
Take care. We're adjourned.